Good evening to the aspirants of the JCJ 2023 of Andhra Pradesh as well as the state of Telangana. Welcome to my virtual class, and today that I am going to deal the commercial courts, commercial division and commercial appellate division of High Courts Act 2015 multiple choice questions. Yes. Now be ready to shoot. Now I'm going to delete. Yes, we can scroll down to up. Yeah. Number one, the commercial court is intended to resolve the disputes of a commercial nature dash A. Expediently, effectively, and efficiently. B. Effectively, expediently, and efficiently. C. Expediently, efficiently, and effectively. D. Efficiently, expediently, and effectively. What is the right sequence? Should A, B, C, or D? No native marks. Should. Unmute and say. Unmute and say which is the appropriate answer among the four. Please speak. Say, I don't know. Say, I don't know. Or you can use your own choice. But say something.
Okay, Professor.
Say something. Say, I don't know.
I don't know, Professor.
Very good, very good. Appreciate. Thus give the sense that I am not teaching to the wall. నేను గోడకు చెప్తలేనని నాకు తెలుస్తుందండి. మీరు మాట్లాడకపోతే నేను గోడకు చెప్తున్నాను అనిపిస్తుంది నాకు. ఆర్ యు ఫాలోయింగ్ మీ?
Yes, Professor.
Yes.
Following you. Yes.
Yeah. The right answer is A. Expediently, effectively, and efficiently is the right answer for the first question. Second question. After the referring to a host of a judgment of the various high courts, the Honorable Calcutta High Court opined that the only a dispute arising out of a transaction between the named clauses of the persons which has been formalized by way of a mercantile document will be a dash under the section 21C1, means class section 2, subsection 1, class C and subclass 1 of the 2015 Act. A profitable dispute. B. A trade dispute. C. Commercial dispute. D. Trade dispute. Which is the appropriate word in the blank? Should anyone? There is no negative marks. Hunch it, anticipate it, and say. Instead of saying, I don't know. Say anything, either A, B, C, D. Imagine. Imagine anyone. Hunch it, anticipate it. I say there is no negative marks. I don't deduct the marks. I don't deduct the marks. Prasad.
Yeah, Professor, commercial dispute.
Keep close your gadget. Keep close your gadget and speak, because you said commercial dispute. Is it?
Yes, Professor. Yes, Professor.
Keep your gadget close. Your voice is so
Okay,
less. Say again.
Okay, Professor. Commercial dispute.
Voice is so low. But anyway, it doesn't matter because it's not recorded. What you said is not recorded. Okay, the commercial dispute is the right answer here. The third question, and increase your volume also, your gadget volume, either your laptop or your smartphone. Third question,
Yes, Professor.
the commercial court shall have the jurisdiction to try all suits and applications relating to the commercial dispute of a specified value arising out of the entire territory of the state over the which it has been vested. Option A, read. Option A, read. Read. Option A.
Dictionary jurisdiction.
No. It's not edible. Pecuniary jurisdiction. Option B. Territorial jurisdiction. Option C. Geographical jurisdiction. Option D. Boundary jurisdiction. Now shoot. No negative marks. Say loudly. Say loudly.
The answer is B, Professor.
No. Your voice is it's not audible. You are close. You speak by keeping the close to your gadget so that a voice is more.
Yes,
The right
Professor. The
answer is B. Territorial jurisdiction is the right answer for the third question.
Yes.
Now the fourth question. Which statement is the correct statement among the four MCQs? A. Commercial dispute shall cease to be a dispute merely because of the presence of the state or its instrumentalities as one of the contracting parties. B. A commercial dispute shall not cease to be the dispute merely because of the absence of the state or its instrumentalities as one of the contracting parties. C. A commercial dispute shall not cease to be a dispute merely because of the presence of the state or its instrumentalities as one of the contracting parties. D. A commercial dispute shall not cease to be a dispute merely because of the presence of the state or its instrumentalities as a single of the contracting parties. So there are four options I have given. Make it down. Yes, among the four options, which one is the correct option? Both the spelling and everything. Say loudly.
The D is the answer, Professor. A commercial dispute shall not case to be dispute merely because
Say the initial. Say the initial first.
D.
DOG dog.
Yes, Professor.
WRONG. Make the second option.
Shall not case.
Make the second option.
B.
B for box.
Yes, Professor.
WRONG.
Oh.
The right answer is C. CAT cat. A commercial dispute, and here I am highlighting it. This is the right answer. A commercial dispute shall not cease to be a dispute merely because the presence of the state or its instrumentalities as one of the contracting parties. Now I will show you that why A is wrong. A dispute shall not. Here I removed the not. A dispute shall not. So A, not I removed, I put the C's. So hence it is wrong. And B, why it is wrong? Merely because of the presence. But merely because of the presence. Where it is? Because of the presence. It is absence. It is the presence, but I wrote absence. So it is also wrong. And C is correct. Why the D is wrong? The D is wrong because a commercial instrumentality is as one of the contracting. Instrumentality is as single of the contracting. I made it instead of saying 1 I made here a single, so that's also wrong. Is it clear? Now the right answer is C is the right answer, which you just now I read it. Yes. Unmute and read this fifth question in a loud voice.
A commercial court has a jurisdiction to deal with any suit of application dealing with a commercial dispute arising within territorial jurisdiction where the value is specified subject matter in a dispute specified value exceed
Read the options.
3 lakhs, 3,50,000, 4 lakhs, 5 lakhs.
Which is the right option?
Answer
Which is
A,
the right
Professor.
answer?
I think answer is A, 3 lakhs.
Yes, answer is the A is the right answer. 3 lakhs is the right answer. You're right. Now the sixth question.
Yes.
The
Yes,
appellant
Professor.
herein executed an agreement to sell the dated 14/2/2012 in favor of the respondent number 2 in respect of the land which is described in the agreement. Respondent number 2 assigned and transferred all his rights under the said agreement to sell in favor of the respondent number 1 by executing an assignment deed dated 12/10/2017. In that view, respondent number 1 herein was to purchase the land which were the subject matter of the government from the appellant herein. Accordingly, the sale was made under the deed of the conveyance dated 3/11/2017. Since the certain other aspects were to be completed regarding the change relating to the nature of the use of the land for the conclusions of the transactions, the right of the appellant in respect of the land was to be protected as the fact of the case. Which is the fact of the case? The above statement, everything. A. Jagmohan Bail versus State Bank of Indore, State Bank of Indore. B. Ambala Surabhai Enterprises Limited versus KS Infraspace LLP and others. C. Vasu Healthcare Private Limited versus Gujarat Akruti TCG Biotech Limited. D. Federation of the AP Chambers of the Commerce and Industry and others versus State of AP. Which is the correct case law, the facts which is stated above. Shoot, even though it is
I
no
have no
negative
idea.
marks. Hunch, anticipate, imagine.
The answer is a B,
B for
Bombay.
yes. Answer, you are right. B is the right answer. That is Ambala Sarabhai Enterprises Limited versus KS Infraspace LLP and others. That is the case law. Now the seventh question. Commercial disputes are defined under the section 2C of the Commercial Courts Act 2015. Number 1. In the routine transaction of merchants, bankers, financiers, and traders, there is a debt over the enforcement and interpretation of the papers. 2. Export and import of goods and services. 3. Admiralty and marine law issues. 4. Transactions involving the aircraft, aircraft engines, aircraft equipment, and helicopters, such as sales, leasing, and financing. Now the options are A, B, C, D. A, 1 plus 2 plus 3. B, multiple choice, 2 plus 3 plus 4. C, choice, 1 plus 3 plus 4. D option, 1 plus 2 plus 3 plus 4.
The answer is B, 2 plus 3 plus 4, Professor.
Repeat.
The answer is 2 plus 3 plus 4, B. B for
Yes,
Bombay.
B is the right answer. Suppose if I say, what is the wrong in the number 1? Can you give me the answer?
In the routine transaction of merchant, bankers, finance, and trades,
Here in the routine
There is debit
transaction of the
over the
merchants, bankers, financiers and traders, there is a debt. I wrote DEBT, debt. Actually, there is a debate, not debt.
Yes.
There is a debate over the enforcement and interpretation of the papers. Instead of writing the debate, I wrote
Yes, Professor.
debt. Okay, that's why first is wrong. Okay, now 8th question. Commercial disputes are defined under section 2C of the Commercial Codes 2015. Number 1. Carriage of goods in a term that refers to the transportation of the things. 2. Tenders or contracts connected to building and infrastructures. 3. Agreement for the use of the immobile property in trade. 4. Agreement for franchising. Now options. A. 1 plus 2 plus 3. B. 2 plus 3 plus 4. C. 1 plus 3 plus 4. D. 1 plus 2 plus 3 plus 4.
C is the 1 plus 3 plus 4, Professor.
Okay, if I say the C is the 1 plus 3 plus 4, what is wrong in the B? What is the wrong in the 2?
Yes, Professor. Tenders and contracts connect to building infrastructure is the wrong answer.
Which is the wrong wording there?
Tenders are contract connected with builders and infrastructures.
The wrong connected here is tenders and, not are. Tenders and contracts. I put R, O-R-R. Is it clear?
Clear, Professor.
Instead of saying tenders and contracts connected to the buildings and infrastructure, I wrote tenders or contract, means any one of them, not both of them. Is it clear?
Clear, Professor.
So hence that is the wrong thing. Yeah, 9th question. Commercial disputes are defined under the section 2C of the Commercial Codes Act 2015. Good. Number 1, agreements for the use of immobile property in trade. 2. Agreement for the franchising. 3. Agreements regarding the distribution and licensing. 4. Agreements for management and construction. A. 1 plus 2 plus 3. B. 2 plus 3 plus 4. C. 1 plus 3 plus 4. D. 1 plus 2 plus 3 plus 4.
C. 1 plus 3 plus 4.
Repeat.
C. 1 plus 3 plus 4, Professor.
Wrong.
Okay,
C. Cat is not the right answer. That means 1 plus 3 plus 4 is not the right answer. Next.
Correct answer, Professor.
No. I will show you the reason.
1 minute.
You take the feedback. Agreement for the management and consulting. Yes, you are right. Agreement of management and construction I wrote. Actually, it is consulting. You have to give the reason also. Why 4th one is not the right answer. So 1 plus 2 plus 3, A is the right answer. Because I say management and construction I said. But it's a consulting. You have to give the reason also why it is. Then it is a good, no doubt you are shooting. I don't know what method that you are applying, but you are shooting. But I would like to know that the way that you are to shooting, you should also have a reason to say that why that answer is right and this answer is wrong. And that is the main important factor that I would like to know. So now let us see the another point. 10th question. Commercial disputes are defined under the section 2C of the Commercial Codes Act 2015. A. Agreement forming a joint venture. 2. Agreements between the stakeholders. 3. Agreements relating to the subscriptions and investments in the service businesses such as the outsourcing and financial services. 4. Agreements on the technological advancements. A. 1 plus 2 plus 3. B. 2 plus 3 plus 4. C. 1 plus 3 plus 4. D. 1 plus 2 plus 3 plus 4. Now give me the answer.
Please up the page, Professor.
Say loudly.
Answer is 2 plus 3 plus 4, Professor.
2 plus 3 plus 4 answer.
Yes, Professor.
Means B. B for Bombay.
Yes, Professor. Yes, Professor.
WRONG.
Please down the paper screen, Professor.
The right answer is 1
A.
plus 3 plus 4. 2 is the wrong. What is the wrong in the 2? Agreements, no wrong. Between, no wrong. Stakeholders, wrong. It is not the stakeholder. It is the shareholders.
Stockholder.
It is the
Shareholder.
shareholders. You know the difference between the stakeholder and shareholder. The term shareholders and stakeholders are sometimes used interchangeably, but they are actually quite different. A shareholder is someone who owns a stock on your company. He owns a stock on your company, and while a stakeholder is someone who is impacted by or has stake in project you are working on it. That means he is only get the benefit for that one, but here he is having the stock in the company. So now the 11th question is type of the commercial disputes, that which MCQ is the correct answer. Number 1, dispute arises between the two businesses because of the breach of the contractual relationship or any other contract related issues which which does fit with the existing contract and leads to a disagreement between the parties. 2, customers whose expectations don't match with the product quality or the services provided by the company or matters related to unfair trade practices are covered under this type. 3, matters which give rise to the IPR infringements between the two businesses or the issues regarding the land dispute in which the said land is used for commercial purposes and also are also covered under the commercial disputes. So I read 1, 2, 3 statements. Now, which option is the correct option? You have to say A, 1 plus 2, B, 2 plus 3, C, 1 plus 3, D, 1 plus 2 plus 3.
The answer is C, 1 plus 3.
The answer is C, means cat. 1 plus 3. WRONG. Second option. Second option.
2 plus
Answer
3,
is
Professor.
Bombay. B. 2 plus 3. The reason is why 1 is wrong. What is the reason? See here, 1 is the wrong because which does not fit. And what I wrote here, which does not fit instead of which does fit. Here. Here, which does not fit. But I wrote does fit. But actually it is does not fit. So I removed the not. Hence it is not appropriate. So answer is 2 plus 3. Now the 12th question. Can you unmute and read the 12th question? Loudly.
The Indian government has been quite tightful in their platform of dash and enhancing the ease of doing business in India. Options A, brand in India, make in India, style in India, made in India.
Shoot the right answer. Try.
Make in India.
It is a make in India is
Make.
the right answer. Means Bombay B is the right answer. Make
Okay,
in
Professor.
India B is the right answer. Now 13th question. The government aims to attain an early resolution of the commercial dispute and also improves the image of the judiciary. India leaped into the dash rank in the World Bank's ease of doing the business ranking for 2016. Now the fill the blank. A, 100 position. B, 101, 101. C, 102 position. D, 103 position in the world.
The answer is 1 or 2, Professor C.
WRONG. Second option.
D, 1 or 3.
WRONG. It is the 100th century. A is the right answer.
Okay, Professor.
Now the 14th question. The Act also provides that the Commercial Appellate Division of High Court shall hear the appeal from the decision of the following tribunals. A. Number 1. Competition Appellate Tribunal. 2. Debt Recovery Appellate Tribunal. 3. Intellectual Property Appellate Board. 4. Company Law Board or the National Company Law Tribunal. Now the options. A. 1 plus 2 plus 3. B. 1 plus 3 plus 4. C. 1 plus 2 plus 3. D. 1 plus 2 plus 3 plus 4.
The answer is A, 1 plus 2 plus 3, Professor.
WRONG. Next. Second option.
1 plus 3 plus 4, Professor B.
WRONG. The right answer is 1 plus 2 plus 3 plus 4. I did not change anything. I did not change anything. That means answer is
D.
answer is
D. D for Delhi.
yes, that is the way. Now 15th question. The act may also expedite in changing the opinion of venture capitals regarding India as an investment dash. A. Center. B option pivot. C option hub. D option middle. Which is the appropriate terminology?
A, center, Professor.
Means A for America.
Yes, Professor.
WRONG.
Professor C, answer, Professor.
C is the right answer. Because you say satellite hub and electronic hub. Do you know what is the actual meaning of hub? HUB hub. If you know it, you tell me. If you don't know, you say, I don't know, sir.
I don't know, sir.
If you see the correct meaning of the hub is, you know, bicycle.
Yes,
You know
Professor.
the bicycle.
Yes, Professor.
In cycle wheel, the spokes are connected to whom? The spokes are connected to whom? Spokes mean అంటే స్పోక్స్ అంటే తెలుసా అండి?
తెలియదు ప్రొఫెసర్.
దేనికి కనెక్ట్ అయి ఉంటాయి?
మెయిన్
One
రోడ్.
end is rim. One end is rim. Is it clear?
క్లియర్ ప్రొఫెసర్.
And the another end is hub. Another ending is hub. The center part of it called hub. And suppose the bicycle, I will show you the bicycle. Then I will see the bicycle images parts. See, this is the bicycle. Did you see the bicycle now? Is it visible? And here I am cursor, I am making cursor. Did you see the cursor? Which I am moving. Did you see the cursor which I am moving?
Okay,
That is
professor.
called the hub. Where the spokes will one attach to the rim, another attached to the hub. That is called hub. The center part of it called hub. So I prepared this much today, and now if you happen to see the syllabus, I mean not syllabus, act. So this is the commercial courts, commercial division and commercial appellate division of High Court within parentheses Amendment Act 2018 it is. But our act is say the year. Say I don't know.
2018.
How much?
2018.
Its amendment is 2018. But original act is original act. (2015). Original act is 2015.
2015.
Here I am showing. See, today is the 8th. And see here, commercial court, commercial division and commercial appellate division of High Courts Act 2015. Yes. So our act is 2015. And hence, what is the act number of the 2015? Supplementary question. See, every act has the number. Am I right?
Yes, professor.
Am I right?
Yes, sir.
What is the number of this 2015 Act? I will try to show you here. Act number, tell me now. I shared on the screen. Tell me the act number.
2015.
I say act number. I did not ask you year. Act number. Here it is given. Why you are taking so much time?
Act number.
Say act number.
Sir. 4.
How much? Act number
4, sir.
4.
Yes, Professor.
Where is the 12 is written? Show me. Where is the 12 is written? See, which I highlighted here. What is given here? Highlighted. Act number
4.
4.
Up to
But why you are
2016.
saying 12? Now you tell me, how many sections are there in the Commercial Court Act? See, sections in the Commercial Court Act, if you happen to go for the last one, then you will understand it. How much are there? See, the verification is there, and the appendices are there, and we'll find the other appendix also here, I believe. Explanations are given. Oh, so much. Disclosure, order 11. This is order 11. But we don't want the order here, but we want the sections. How many sections are there? This is a schedule. A schedule is connected with the section 16. And when you turn to this one, and this is a chapter 6, means chapter 6, chapter 7, 17, 18, 19, and 22, 23, then schedules are there. So, how many sections are there? How many sections are there?
23, Professor.
23 sections are there. How many chapters are there? Chapters. How many chapters are there?
7 chapters, sir.
Huh?
7 chapters.
7 chapters are there. How many schedules are there? One schedule.
Yes, Professor.
And one schedule refers to which section? One schedule refers to which section? It is on the screen. Why you are taking so much time?
16 sections, Professor.
Yes. Give me the answer.
16 section, Professor.
16 sections are there. Why you are getting fear? Say it loudly. So now schedules are given there. Then these are all advertisements comes in that way. And then we will see the down. And here orders are there. Order is 11th order. Order 11 is here. And then any other orders in addition to the 11. Yeah, order 13A also there. Order 13 capital A, that is a summary judgment also there. Then probability I am giving. How we can make it out. Then appendix also there, one appendix. So
Yes, Professor.
then afterwards the verification. So they may ask there, how many appendix are there, how many orders are there. So probability I am saying.
One.
At that instance, you should be in a position to give the answer to the questions. So today that I will wind up with this and the next tomorrow, as usual, the time, that is the Sunday, it is a holiday, but I did not take the class yesterday, Friday. So the Friday class, I will compensate on tomorrow. What is the Friday class? 7th April. It is there on the screen. Even by looking at also, you are not giving the answer.
Protection of children from
Protection of children from the Sexual Offence Act
Sexual
2012.
Offences Act 2012.
That I am
Professor.
going to deal tomorrow. As usual time, India time is 8:30. Is it clear? Say yes.
Clear, Professor.
Yeah, with this I would like to stop my today's class and Jai Hind. Yes, end of the meeting. Jai Hind, right? सारे जहां से अच्छा हिंदुस्तान हमारा। जय हिंद।